Hello, Cyril.
Good afternoon. How are you?
Good afternoon. I'm fine, thank you. You'll be the one doing our Portuguese interpretation, correct?
Yes, I am.
Okay, let me go ahead and
My name. Okay.
Okay, so you can speak to the Portuguese channel. Can you hear you? Can hear you. Thank you. All right, in the English channel. Yes, we can. Okay, thank you.
Good afternoon, colleagues, partners, participants. Let us wait just 1 minute for more people to join. Then we will start the webinar. Thank you. Good afternoon, distinguished guests, partners, colleagues, and ladies and gentlemen. Welcome to the official launch of the scorecard on state compliance with the African Commission principles on the decriminalization of petty offenses in Africa. My name is Meron Shatu. I am a program officer at the Network of African National Human Rights Institutions, NANRI. It's my pleasure to be your moderator for today's webinar. Thank you all for joining us and being part of this important launch. I would like to warmly welcome and recognize the presence of representatives from the African Commission on Human and People's Rights, national human rights institutions, civil society organizations, researchers, partners, and everyone joining us today. I would like to also recognize and welcome the members of the media who are joining us today. We appreciate your presence and look forward to your coverage of this important launch. Today marks an important milestone. We are here to introduce a practical tool developed by the Network of African National Human Rights Institutions in collaboration with APCOF and the campaign on decriminalization of petty offenses, of course, with the support from Open Society Foundation. This scorecard was piloted in 3 countries, namely South Africa, Kenya, and Cote d'Ivoire, and we are hoping to expand it to more countries in the future. We firmly believe that the scorecard that we are launching today will be an important tool for tracking how states are implementing the African Commission's principles on decriminalization of petty offenses. It will also help us to monitor progress, identify gaps, and also support advocacy efforts. I will not go into detail about the scorecard at this stage, as our panelists will shortly share the background and also provide a live demonstration of the platform. But before we begin, let me briefly take you through today's agenda. Allow me to kindly share with you, share the agenda on the screen. I hope you all can see my screen. Yeah, as you see on the screen, we will begin with an opening remark with our Executive Director, Mr. Gilbert. Then we will move into our context setting session, where we will discuss the progress, the challenge, and also human rights impact of petty offense laws in Africa. This will be followed by a Q&A session where we expect participants to ask questions to our panelists. After that, we will dive into the scorecard, where we will hear about the background, wait a minute, where we will hear about the background of the scorecard, and also the indicators and methodologies used to develop this scorecard. Then it will be followed by a live demonstration of the scorecard itself. Finally, we will move to the official launch of the scorecard itself, followed by a Q&A session. Yeah, before moving to the final launch, we will give chances to participants to ask questions. Without further ado, let us officially begin. It's now my pleasure to invite Mr. Gilbert Tibogo, the Executive Director of Network of African National Human Rights Institutions, to give the opening remarks and officially set the stage for today's discussion. Mr. Gilbert, the floor is yours. Thank you.
Thank you, Meron. Thank you very much. Honorable Maria Teresa Manuela, the Special Rapporteur on prisons, conditions of detentions and policing in Africa of the African Commission on Human People's Rights. Mr. Sean Tait, the Director of the African Policing Civilian Oversight Forum, APCOF. Mr. Demas Kiprono, Executive Director of ICJ, Kenya. Distinguished guests, representative of national human rights institutions, civil society organizations, our valued partners, colleagues, ladies and gentlemen. It is my distinct honor and privilege to welcome you to today's launch of the scorecard on state compliance of the African Commission Offences. I sincerely thank every one of you for taking the time to join us today. The launch is especially meaningful. It coincides with the International Day for International Criminal Justice. While this day is often to grab crimes, it also reminds us that justice begins much earlier with laws that protect people rather than punish poverty, vulnerability, or circumstance. Across Africa, thousands of people enter the justice system each year, not because they pose a threat to society, but because they are homeless, unemployed, street vendors, or simply trying to survive. Too often, poverty itself becomes criminalized. Across the continent, offenses such as bankruptcy, begging, loitering, sleeping in public space, and unless the street vending continue to disproportionately affect people living in poverty and other marginalized communities. Rather than addressing the root causes of exclusion, these laws frequently lead to arbitrary arrests, unnecessary detention, harassment, and discrimination. They contribute to overcrowded places of detention, consume scarce public resources, and undermine public confidence in justice institutions. Recognizing these challenges, the African Commission on Human People's Rights adopted the principles on the decriminalization of petty offenses in Africa in 2017. The principles provide practical guidance to states on reviewing laws and policies that criminalize poverty and status while aligning domestic legislation with the African Charter on Human People's Rights and other regional and international human rights standards. This position has since been reinforced by the African Court on Human People's Rights. In its advisory opinion requested by the Pan-African Lawyers Union, the court found that laws criminalizing conduct associated with poverty, homelessness, and social status are incompatible with the African Charter. It called on states to review and reform legislation that unjustifiably restricts dignity, equality, liberty, and freedom of movement. The network of African national human rights institutions was honored to contribute to these proceedings as amicus curiae, providing evidence that demonstrated how these laws disproportionately criminalize poverty rather than criminal conduct. Together, the African Commission on Human People's Rights Principles and Court Advisory Opinion provide a clear roadmap for reform across Africa. Yet, despite this progress, implementation remains uneven. Many states continue to retain outdated laws inherited from colonial legal systems, while others have begun reform but continue to face practical challenges in implementation and monitoring. Distinguished participants, for NANRI, today's launch represents the culmination of several years of work. Since 2018, with the support of the Open Society Foundations and in partnership with APCOF and the campaign to decriminalize poverty and status, NANRI has worked to strengthen the capacity of national human rights institutions to monitor implementation of the African Commission's principles, support advocacy, and contribute to legal reform. The scorecard is one of the key outcomes of that collective effort. It was developed through an extensive consultation process involving national human rights institutions, government, oversight bodies, civil society organizations, and technical experts. It was subsequently piloted in Kenya, South Africa, and Cote d'Ivoire, enabling us to test both the methodology and its practical application across different legal and institutional contexts. The lesson from these pilot countries have strengthened the final product that we officially launch today. Beyond this initiative, NANRI continues to promote justice sector reform across Africa through programs on torture prevention, preventive monitoring of places of detention, OPCAT ratification, the establishment of national preventive mechanism, and stronger collaboration among justice sector institutions. Although these initiatives address different issues, they share one common purpose of ensuring that justice systems protect rights, uphold dignity, and strengthen the rule of law. As I conclude, I wish to emphasize that the launch of this scorecard marks the beginning of a new phase in our collective efforts. Its success will depend on the continued engagement of national human rights institutions, civil society organizations, government, researchers, and partners across the continent. I look forward to the discussions and demonstration that will follow, which will provide further insight into the scorecard and its potential to support monitoring, advocacy, and reform efforts. I'm confident that today's engagement will strengthen our collective commitment towards advancing the implementation of the African Commission's principles on decriminalization of petty offenses in Africa. With these remarks, I welcome you once again and wish you fruitful discussions. I thank you for your kind attention.
Thank you very much, Mr. Gilbert, for those important remarks and also for setting the foundation for today's launch. We will now move into session 2, where we will be exploring the progress made, the challenges that remain in implementing the principles on decriminalization of petty offenses, and also the human rights of petty offenses laws in Africa. From my screen. Our first speaker is Honorable Commissioner Maria Teresa Manela, Commissioner and Special Rapporteur on Prisons, Conditions of Detention and Policing in Africa at the African Commission. However, I don't see Commissioner online. While we give Commissioner Manuela some time to join us, I will give the floor to the next speaker, Mr. Kiprono, the Executive Director of the International Commission of Jurists, ICJ Kenya. Drawing from the experience he has in legal advocacy and also human rights works, Mr. Kiprono will provide a reflection on how petty offense laws affect individuals and communities, and also why rights-based approach remains essential in shaping a meaningful reform. Thank you, Mr. Kiprono, for joining us. The floor is yours.
Thank you very much. As you heard, my name is Dimas Kiprono, working with the Kenyan section of the International Commission of Jurists. First of all, ICJ Kenya is among the first organizations that began doing research and advocacy on the issue of petty offenses. Because from the data that we were seeing is that this so-called petty offenses, the classification of it really affects the marginalized and the poor in society and tends to otherize people. And it begins with the colonial experience, whereby certain spaces were supposed to be exclusive for the colonizer, and for them to be able to police those areas, certain offenses were put in the books to basically separate people, to ensure that either the person is there to work, and if they're not working, they are vagabonds, they are loitering, and so on and so forth. Kenya has made very intentional strides in terms of looking at the issue. And this begins, first of all, in 2015, when the National Council on the Administration of Justice, which is a body that comprises of all justice sector actors, from the state, the judiciary itself, civil society, those who work on issues of children, those who work on issues of prison conditions, those who work on policing, and so on and so forth. And this organ, first of all, decided to really have data. And so it commissioned a study and an audit on the criminal justice system. And lo and behold, 3 years later, when the study is done, it was clear that the criminal justice system is predominantly looking at or is clogged by persons who are young, persons who are poorer, and those people were there because of petty offenses. This realization really led to an escalation where, for the first time, the stories of persons charged with petty offenses was being seen from a lens of human rights, whereby the discriminatory nature of it, the way that these crimes tend to be victimless, the way that these crimes tend to lead to socioeconomic, psychological effects, and also that it increases the number of times a person interacts with the criminal justice system, which increases the socioeconomic effects, increases their chances of recidivism, and at large, taken as a whole, it was really egregious to the human rights of the people. And the Attorney General, the Office of the Director of Public Prosecution, in and around 2020, directed his prosecutors not to prosecute persons arrested for touting. And so you can tell that at this point, this was not a policy direction from Parliament or something from the judiciary. This came from the prosecutor himself, having seen the effect and having been a member of the National Council of Administration of Justice. And this was actually hailed. But then the laws remained in the statutes. And so the National Council of Administration of Justice began a process of looking at the laws. So doing an audit of the penal code, looking at what provisions of the penal code classify petty offenses, which ones are the ones that are egregious. And
It seems like we lost Mr. Kiprono. Can anyone hear Mr. Kiprono? I hope it's from my end.
Oh, it's from his end.
Okay. Let's just give him some time to rejoin. Thank you. It seems we lost Mr. Kiprono. I don't see him on the list. Perhaps he was raising a very good point surrounding petty offenses. And I believe that the challenge that he was raising need a comprehensive and practical tool. And I believe the scorecard that we are launching today can be a very comprehensive tool to address those challenges. While we wait Mr. Kiprono to join, as well as Commissioner Manela, Dailan, can you please confirm if Commissioner Manela is online? I don't think Commissioner Manuela is online, so we will move to the second session, and we will come back to the first session when we have our speakers back. So the second session will be we will now we hear from our other speakers, and this session will look at the practical tool developed to track progress on state compliance with the principles, recognizing the challenges and gaps we have seen, and Mr. Kiprono just raised briefly, of course. NANRI, in collaboration with APCOF and the campaign on decriminalization of petty offenses, has developed the scorecard to help address the need. To give us a better understanding of how this initiative came about, my colleague Edward Sikesa will take us through the background and motivation behind the development of the scorecard. Edward, the floor is yours.
Thank you very much, Meron. So my name is Edward Sekisa, and I lead our work on torture prevention here at NANRI. It is indeed my pleasure to provide some background on the journey that has brought us on today's launch of the scorecard on decriminalization of petty offenses. But before we look at the scorecard itself, it's important to begin in the context that made this initiative necessary. So across Africa, many criminal justice systems continue to operate under laws that were inherited from the colonial era. And we see that these laws were created in a very different time and in a very different purposes. So rather than just promoting justice and public safety, many were designed to control communities and regulate poverty. So today, some of these laws exist in different forms, and they include offenses relating to vagrancy, loitering, and even rogue and vagabond. So although they appear minor, the impact on people's lives is not anything but is not minor per se. We see that too often these laws are used against people who are already among the most vulnerable in society. That is the informal traders trying to earn a living, people experiencing homelessness, persons with disabilities, and others living in poverty frequently become the primary targets of enforcement. In effect, uh, people are not always punished because they have committed serious crimes. We see that they are always punished because of the circumstances, and that is why the issue of petty offenses is a fundamentally human rights issue. So the consequences extend beyond the individual who is arrested. We see that families tend to lose income in a situation where the breadwinner is detained. There are some situations where children may leave school because of the household resources disappear, and so forth. Um, in many detention facilities across the continent, they continue to struggle with overcrowding. This due to the fact that petty offenders make up a significant portion of those detainees because they are unable to relatively pay those small fines or secure bail. So this places enormous pressure on the already limited public resources, while reducing the capacity of the criminal justice institutions to focus on more serious offenses. Recognizing these challenges, the Africa Commission on Human and People's Rights has over the years developed an important regional framework to guide reform. We see that this work has evolved through some key regional instruments, beginning from the Wadagodu Declaration in 2003, and we also have the Rwanda Guidelines, and ultimately leading to the adoption of the principles of petty offenses in Africa in 2017. Together, these instruments provide a very clear direction to member states. They do encourage a shift from criminalizing poverty towards approaches that uphold dignity and justice in line with the African Charter. However, there has not been any consistent way of measuring how states are implementing these principles in practice. We see that progress has often been difficult to assess, and the National Human Rights Institution had not had a common tool for monitoring the implementation, or rather comparing developments across different countries. So it is this gap that led to development of this basic scorecard. We find that the idea behind the scorecard emerged through our collaboration with the Africa Policy and Civilian Oversight Forum in 2022. And we wanted to have a practical tool that could help us generate measurable information on how states are giving effect to the principles on decrim of petty offenses. So the scorecard is therefore a tool that is designed to monitor these principles. So it provides an overall picture of the state's compliance with these principles and helps translate the regional commitments into practical evidence. Importantly, see that the scorecard also recognizes the unique role national human rights play. Of course, the National Human Rights should have a monetary mandate in terms of monetary places of detention, engaging with the government, and promoting reforms. So the scorecard work is just to provide a common methodology that enables the national human institutions to document the developments, monitor the progress over time, and support evidence-based advocacy at the national level. And to achieve this, the scorecard focuses on 4 areas that reflect the core objectives of the principles of decriminalization of petty offenses. First, the scorecard examines the freedom of discrimination, looking at the laws that disproportionately affect the poor and the marginalized community. Second is that it considered the freedom of from ill treatment, including how the enforcement of petty offences contributes to prison overcrowding. Third is that it assesses the freedom from arbitrary arrest, asking whether the existing laws are unnecessary, abroad, or disproportionate. And finally, it examines the implementation measures, including whether the governments are taking practical steps such as legal reform, uh, training officials, or introducing alternatives to criminal sanctions. So together, these 4 areas provide a balanced picture of how states are progressing in implementing these principles. So the broader objective is basically to strengthen accountability, as well as encourage reforms where they are needed, as well as support greater understanding of the principles across the continent, and provide reliable evidence that could inform discussions and ultimately legislative change. We see that in terms of developing this tool, it has been very gradual, and it has been a very collaborative process, of course, with support from the Open Society Foundations. The work moved into an intense phase in 2023 with APCOF providing technical support in the development of the methodology, also as well as in data collection and the training materials. So the methodology was then tested through some pilot activities here in Kenya, in South Africa, and in Cote d'Ivoire. So these pilots provided some very practical experience, demonstrated that both the potential of the scorecard and the challenges that the NHRIs face when collecting information from the different parts of the criminal justice system. So throughout the process, there were some very, very extended consultations with the NHRIs, with some oversight bodies, as well as the judicial actors and the CSOs, and their feedback proved very extremely valuable. So one important lesson to note from some of the information that was originally envisioned was that originally vision was not consistently available across the 3 countries. In many cases, official arrest or detention data was incomplete, or there was difficulty in accessing the data. So rather than just allowing this to become a challenge, we used these lessons to strengthen the tool. So it is in 2025 that we refined the methodology and try to sort of simplify it. So instead of requiring large volumes of data that could delay the implementation, the scorecard was evolving to a practical tool that remained robust while at the same time being user-friendly. So this refinement is what has made the scorecard to be more sustainable and ultimately more effective as an advocacy tool. Colleagues, so today's launch represents a new monitoring tool. represents years of collaboration, years of learning, and years of continuous improvement. And more importantly, it demonstrates a shared commitment to strengthening accountability and ensuring that the principles of Decrim become more meaningful in practice and not in policy. So going forward, the scorecard will support the national human rights institutions in their advocacy efforts. The scorecard will also assist the regional monitoring processes and increase public awareness of the human rights impact of criminalizing poverty. So while today's launch builds on the experience of the 3 pilot countries, we see that it also marks the beginning of a broader rollout to the NANRI membership, as well as the wider GANRI network. So this scorecard provides something that has been missing for years, and that is the practical way of measuring progress, identifying gaps, and supporting meaningful reforms. So it will help us turn the regional standards into practical action and strengthen our collective efforts to ensure that the justice system protect the dignity and rights of every person. Thank you.
Thank you so much, Edward, for sharing the background and highlighting the vision behind this important initiative. This has given us a better understanding of why the scorecard was developed and also the value it brings in supporting efforts to track progress and identify gaps in implementation. I would like to welcome Honorable Commissioner Maria Teresa. We are pleased to have you join this meeting. We lost Mr. Kiprono for a moment and had moved to the next session. Since Mr. Kiprono is back, we would be happy to give you the floor to continue with your presentation. Thank you very much, Mr. Kiprono.
Thank you so much. I apologize for that technical hitch. Yes, so I had begun by giving the historical background, so the colonial history, and then we went to the national audit that was done by the National Council on Institution of Justice, which is the highest organ of criminal justice actors in Kenya. And after that audit, I said that the Office of the Director of Public Prosecutions actively um, um, uh, directed his prosecutors not to prosecute certain petty offences. And then after that, the National Council came up with a bill that would declassify several of these problematic laws. And everything went smoothly in terms of the drafting of the bill. But as a challenge and as a lesson learned, when the bill was presented to Parliament and then which made it public to the media, perhaps what we did not do properly is to really prepare the nation for why petty offences are unconstitutional, anti-human rights. And so the media just pulled part of it, and one of the recommendations was that sex work be decriminalized. And the next day, the title was that Chief Justice wants to decriminalize sex work, wants to make sex work legal, forgetting all the underpinning issues that were going on and the human rights considerations. And this really caused a backlash. And so even as we now launch this scorecard, which is a very good initiative in terms of furthering justice and equality in society, we must be alive to the hard-held beliefs and perceptions and really direct our advocacy and our educational programs to ensure that we move along with the people in order to further justice. But just saying that in the Kenyan case, we have found that African court advisory opinions, African court principles, have a very persuading effect on our courts. And so even as we continue this journey, um, uh, the door is open for other means of interventions, including public interest litigation, to ensure that some of these laws that are really egregious in terms of being vague and overly broad, in terms of targeting vulnerable members of society, that they are decisively dealt with. But as ICJ Kenya, we'll continue the journey to ensure that justice and human rights is a principle that affects everyone equally. Thank you.
Thank you so much, Mr. Kiprono, for that grounded presentation. As we continue working to better understand and address the challenge around petty offense, I believe that strong monitoring tools are essential to help us track progress and identify challenges over time. And with that in mind, I'm confident that you also mentioned it that the scorecard we are launching today will be an important step in providing a clearer picture of where states stand and supporting efforts to advance the decriminalization of petty offenses. Thank you once again, Mr. Kiprono, for your insights. It's my pleasure to welcome again Honorable Commissioner Maria Teresa Manuela, Commissioner and Special Rapporteur on Prisons, Conditions of Detention and Policing in Africa at the African Commission on Human and People's Rights. Honorable Commissioner, thank you for joining us today. We are eager to hear your perspectives on the progress made and also the challenges that remain in implementing the African Commission's principles on the decriminalization of petty offenses. Honorable Commissioner, the floor is yours. Thank you.
Muito obrigada, Meron, pelo convite e peço sinceras desculpas, pois eu condicionei pensei que fossem 15 horas de Angola, mas afinal são 15 horas aí no Quênia, então temos 2 horas de diferença, mas pronto, estou aqui para tentar partilhar o que tenho com a organização. Não sei se me concedem, se posso partilhar a tela. Se puder partilhar a tela, agradeço. Vou tentar. Ok, muito bem. Parece-me que consegui. Vamos ver como é que consigo isso. Janela.
Yes, Commissioner. I believe you can share your screen.
Ok, obrigada. Yeah. Muito obrigada. Então, vamos tentar de forma sucinta para o tempo que nos foi concedido. E vou falando devagar para permitir que o intérprete possa acompanhar-me. Portanto, para este convite foi-me solicitado que, como parceiros de sempre, pudéssemos falar sobre a questão da descriminalização dos pequenos delitos. Nós, Comissão Africana, temos então por este lema: proteção, promoção e interpretação. Temos uma visão que é uma África caracterizada por respeito e observância estrita dos direitos humanos. Temos uma missão que é promover, controlar e proteger os direitos humanos e os direitos dos povos. E temos princípios pelos quais nos organizamos. E um deles é mesmo a equidade, a não discriminação, a inclusão no exercício do seu mandato no geral. E é este princípio que transfiro para as questões que aqui vamos discutir, que são os princípios relativos à descriminalização de pequenos delitos em África. A interpretação está passada, Meron?
Yes, Commissioner, we can hear you.
Ok, obrigada. Ok. Por decisão da Resolução 366, como é consabido, e durante a sua 21ª sessão, a Comissão decidiu elaborar princípios que discriminassem e despenalizassem pequenos delitos. Isto devido a preocupações levantadas em função dos artigos 2º, 3º, 5º, 6º e 18 da Carta Africana. E queríamos ajudar que no momento da promulgação, da interpretação e da aplicação da legislação e dos regulamentos, os Estados tivessem em atenção o respeito por estes articulados. E isto permitiria o quê? Tratando-se de pequenos delitos, teriam outras soluções mais sociais do que as soluções prisionais e criminais que contribuem sobremaneira para a superlotação das prisões. Isto também permitiria melhorar a justiça para os pobres e marginalizados. Desta forma, estaríamos a dar cumprimento à promoção e à proteção dos direitos humanos. Qual é o objetivo principal destes princípios? É a orientação que fornecemos aos Estados no sentido de descriminalizar e despenalizar comportamentos que não são muito graves e podem ser invertidos. Então, para dar resposta à forma como essa promulgação, interpretação e a implementação pelos Estados desses articulados são feitas, e ajudar também que os Estados-partes se conformem com a Carta Africana dos Direitos Humanos e dos Povos, também com o Protocolo de Maputo e agora com o Protocolo sobre Pessoas com Deficiência e o Protocolo com pessoas idosas. Não é menos importante a Carta Africana dos Direitos e Bem-Estar da Criança. Ora, ao adotar os princípios, em 2018, há uma estrutura que é sobejamente conhecida e sobre a qual não vou falar agora, mas nos estudos que fizemos, tivemos alguns indicadores que vamos abaixo revelar, mas percebemos que ao criminalizar essas condutas menores, enviavam para a cadeia crianças, mulheres, pessoas com deficiência, pessoas idosas, todas elas da faixa etária, portanto, de uma faixa vulnerável, mas também pessoas cujo aspecto social não era bem aceito em alguns territórios. E então, esse impacto negativo sobre esta faixa da população, que recaía exatamente sobre pobres, vulneráveis, devido ao seu gênero, à sua idade ou à sua deficiência. Punia-se para quê? Ou pune-se para quê? Para segregar, para controlar, e isto mina o respeito pela dignidade da pessoa humana e criminaliza o estatuto pessoal desta faixa etária. E muitas vezes até, no caso que nos levou ao movimento sobre a descriminalização, são as pequenas atividades que estas pessoas sem posses realizam por vezes na via pública e que a parte do Estado ou os órgãos do Estado entendem que não é a melhor forma de sobreviver. Isto mostrou-se com maior relevância durante a pandemia da Covid-19, com aquele imperativo: fique em casa. Para além dos instrumentos da Comissão Africana, também temos outros judiciais que consideraram essa criminalização de pequenos delitos como uma violação à Carta Africana. Refiro-me ao parecer do Tribunal Africano e também à decisão do Tribunal da CEDEAO. Por causa disto e por causa da nossa missão de promoção e proteção, aderimos à campanha de divulgação com os parceiros aqui presentes, concretamente com a Open Society, a APCOF, o RINAD e a plataforma da campanha para a descriminalização de pequenos delitos. Auxiliamos na internalização desta campanha com a nossa participação, bem como outros parceiros, No simpósio organizado pela Faculdade de Direito da Universidade de Miami, isto em 2019. Houve discussões muito interessantes e nós, Comissão Africana, apresentamos a nossa caminhada para a descriminalização dos pequenos delitos e que medidas teríamos tomado para sustentar esta caminhada. Eu trago para ilustrar este trabalho que foi feito de forma profunda a nível de Miami e que até hoje temos tido feedback de que a nossa caminhada está sendo replicada pelo mundo. Portanto, hoje esta campanha de descriminalização de pequenos delitos já não é apenas de África, está se tornando do próprio mundo, ali onde ainda temos estes pequenos problemas de criminalização de infrações menores. Como eu dizia no painel anterior, na Covid-19 nós assistimos ao exacerbar da criminalização da pobreza. Mas nessa altura, apesar do confinamento, ainda fizemos o lançamento da versão simplificada dos princípios, com uma linguagem muito simples e com cartazes apelativos para ajudar os Estados e a sociedade civil a tratarmos desta questão relacionada com criminalização de pequenos delitos. Também não paramos por ali. Nós temos estado, portanto, a divulgação e a massificação dos princípios não ficou por aí. Isto não quer dizer que não tenhamos desafios. Nós temos desafios e são muitos. Destacar apenas o desafio da tradução dos princípios em línguas faladas nas várias latitudes africanas para melhorar a sua compreensão e permitir a monitoria por parte dos destinatários finais. Também a sensibilização com outros atores estatais. Estamos a falar da sensibilização em relação ao poder legislativo, que é que, em última instância, deve resolver estas questões, retirando das leis nacionais questões relacionadas com pequenos delitos e evitando fazer leis que introduzam ou reintroduzam estas questões. Também vamos trabalhar com o Poder Judiciário, que é aquele que abre a porta ao sistema penitenciário, porque quando forem presos pela polícia, eles serão inseridos no sistema judiciário, então é preciso que o sistema judiciário também domine e dissemine estes princípios para permitir que, ao julgar, em última instância, os tribunais decidam pela não aplicação da pena de prisão a crimes de pequena gravidade, porque temos outras formas de punir. E ali vamos também chamar a colação ao Poder Judicial para o uso de penas alternativas que dão mais eficácia, conferem mais eficácia à decisão judicial do que realmente as prisões. Se a memória não me atrasoa, em 2023 tivemos uma atividade que levou a falarmos sobre os custos, os cálculos de colocar pessoas que se chamam infratores no sistema judicial, o que isto pesa na fatura orçamental dos Estados. Falamos nas elevadas despesas para a manutenção das pessoas encarceradas e também falamos do desgaste das próprias instalações físicas que levam a que as pessoas estejam mal acondicionadas. E isto leva-nos a outras consequências sobre tortura e outras tantas. Isto leva-me exatamente às nossas prisões. Trago aqui duas fotografias que são públicas, uma na Nigéria e outra no Haiti. A do Haiti foi retirada exatamente na época da Covid e vemos que várias pessoas encarceradas, apesar de algumas terem a máscara, sabemos todos que não foi a atitude mais eficaz levarmos para o sistema carcerário pessoas que por alguma razão, violaram o princípio fique em casa. Não sei o tempo que me deram, vou tentar ser mais rápida. A história de África todos nós conhecemos e isto leva-me a 1996, quando foi adotada a Declaração de Kampala. Trazia-nos questões relacionadas com prisões. E então, o que é que mudou desse tempo para cá? Do acompanhamento que temos feito, continuam dificuldades na gestão de prisioneiros e instalações prisionais, continuam problemas na manutenção das instalações prisionais. Isto leva à superlotação das instalações prisionais, porque elas não foram feitas para esse fluxo de pessoas. Isto inflaciona políticas e programas para a reintegração das pessoas a nível da sociedade depois de passarem pelo sistema carcerário. Eu dizia acima que na preparação do estudo que levou à adoção dos princípios sobre descriminalização de pequenos delitos, foram encontradas algumas razões que hoje podem ser atualizadas, que levaram pessoas para o sistema prisional. Exercício de atividade de subsistência em locais públicos. Em Angola, nós chamamos venda ambulante, e eu sei que este é um fenômeno que se repercute por quase toda a África, e se não for querer muito, pelo menos na África subsaariana. A ociosidade por falta de emprego para a juventude, a mendicidade por causa do êxodo que leva pessoas para as cidades e ficam sem ocupação e dedicam-se à mendicidade, o aspecto físico destas pessoas, a desobediência aos pais, às autoridades, várias questões que nós aqui elencamos e que levaram à adoção dos princípios. Se repararmos com alguma atenção, veremos que todas essas questões afetam maioritariamente pessoas que vivem em situação de pobreza ou extrema pobreza. Algumas dessas situações são de leis antigas, mas outras são de leis novas que estão sendo introduzidas. Razão pela qual antes eu disse que há um desafio de trabalhar com os órgãos legislativos e os órgãos do judiciário, mais concretamente do judicial, para que, ao tratarmos de leis, possamos verificar se efetivamente a prisão efetiva é a medida mais eficaz para que haja menos gente nas prisões.
My commissioner,
Yes.
given the
São mais
time,
2
I kindly
minutos.
invite you to share
São
your
mais 2
final
minutos, já estou a
reflection.
terminar. Ok. Eu trago aqui por que é que nós estamos a discutir isto? Porque o lançamento do quadro de resultados leva-nos ao princípio. Porque hoje cumprimos mais uma etapa e balanceamos os estados, o trabalho feito pelos estados escolhidos. Os testes foram feitos nesses países que vocês elencaram, cujos resultados serão lançados, e então o lançamento desta plataforma é o resultado deste trabalho todo. E também porque hoje é dia da justiça penal e a discriminação de pequenos delitos vem a propósito. Eu vou concluir dizendo que a comissão pode envolver-se diretamente, não pode envolver-se diretamente com os Estados-partes, mas as instituições nacionais de direitos humanos afiliadas e as ONGs com estatuto do observador podem perfeitamente levar esse soft law nas discussões quando houver alteração de legislação. Também, e nós sabemos que esse papel pode ser bem feito. A comissão pode também fornecer ajuda técnica a estas duas instituições para poder auxiliar na internalização das normas da soft law no serviço interno, a nível do inglês chamam domesticação. Então, nós temos ciência que há limitações internas das instituições nacionais de direitos humanos e da sociedade civil, por limitação de recursos, por compressão do espaço cívico, mas essas situações podem ser utilizadas de forma inversa. Então, este quadro de resultados é um exemplo de uma colaboração que pode existir entre as instituições nacionais de direitos humanos, as organizações da sociedade civil e os Estados-parte. Nós preferíamos contactar os Estados daqui a 2, 3 anos para dizer, olha, no seu país há uma instituição nacional de direitos humanos e há uma ONG que pode auxiliar a adequar a sua legislação aos instrumentos regionais e internacionais. Eu vos agradeço pelo tempo que me concederam e peço mais uma vez desculpas pelo fato de ter entrado tarde, porque estamos em sessão na Comissão Africana. Obrigada.
Thank you very much, Honorable Commissioner, for sharing your valuable insights from the Commission's perspective. Your contribution has reminded us that decriminalizing petty offense is not only about changing laws, but it's also about making sure that those laws are translated into practice and that they protect the people who need the most. Thank you once again, Honorable Commissioner, for those important insights. And I would like to thank both our speakers, Mr. Kiprono, as well, for the insightful presentations. We will now open the floor for questions from the audience. If you have any question, please raise your hand. I will then give you the floor, but due to time constraints, we only take 2 questions. I don't see any hand raised. Okay. Yeah, I see Osman here. Can you please introduce yourself, just name and organization, then proceed to your question. Thank you. We
Bonjour
can't
à
hear
tous.
you.
Oui, je vous remercie pour cette présentation particulièrement enrichissante. Au nom de la Commission des droits de l'homme du Cameroun, je salue cette initiative très enrichissante et qui constitue un outil précieux pour accompagner les États dans la mise en œuvre des principes de la Commission africaine relatifs à la dépénalisation des infractions mineures. Je crois qu'il y a lieu de souligner que la question de la protection, en ce sens, demeure un enjeu important, notamment en ce qui concerne la surpopulation carcérale, le recours à la détention provisoire et la proportionnalité. Alors, relativement à ce webinaire, qui me semble un peu très particulier, j'essaie de savoir, est-ce que je ne sais pas si c'est une ONG, mais je sais quand même que c'est une ONG internationale. Est-ce qu'elle s'intéresse beaucoup plus à un mécanisme d'accompagnement technique des institutions nationales des droits de l'homme, comme la Commission des droits de l'homme du Cameroun? Comment est-ce que vous pensez la mise en œuvre effective de ce tableau de bord qui sera lancé aujourd'hui à travers cette grille? Merci. Vos réponses sont attendues. Merci.
We couldn't hear your question. The interpreter couldn't hear your question. Can you please repeat and kindly be brief, just 1 minute?
OK. La question est celle de savoir, est-ce que vous prévoyez un outil ou un mécanisme d'accompagnement technique des institutions nationales des droits de l'homme afin de faciliter l'utilisation de cet outil pour le suivi des réformes nationales et le dialogue avec les pouvoirs publics? Si vous voulez bien, est-ce qu'il existe après ce lancement de la grille relatif aux infractions mineures, est-ce qu'il existe un outil technique que vous avez mis sur pied pour pouvoir accompagner les institutions nationales des droits de l'homme, comme la Commission des droits de l'homme du Cameroun, pour pouvoir mettre en évidence ces projets d'envergure majeure? Merci.
Thank you very much for your question. I hope Honorable Commissioner Maria Teresa Manuela will respond to this question. But before that, I saw another hand. Lionel,
Oui,
please proceed with your question.
bonjour, vous m'entendez? Can you hear me?
We can't hear you.
Okay, maybe I will go in French. Just quickly, merci à l'honorable commissaire pour le rappel de ces principes et aux différents intervenants pour ce grand chantier. Comme ça a été rappelé, effectivement, les questions liées à la criminalisation des infractions mineures a des conséquences sur la surpopulation carcérale, qui sont des programmes que l'on mène beaucoup en Afrique subsaharienne. Peut-être une des questions majeures que l'on retrouve dans le travail de la société civile auprès des autorités nationales et qui pourrait nous appuyer, je pense, dans le plaidoyer pour les réformes du code pénal notamment. Souvent, ce qui nous est rétorqué, c'est de la question de la liste des infractions mineures ou la définition claire de ce qu'est une infraction mineure avant d'aller, puisqu'en fait, on rentre dans un jeu de négociation avec les États, de dire, tiens, est-ce que tel type d'infraction va être considéré comme une infraction mineure? Et finalement, à quel degré, à quel niveau on peut le considérer comme une infraction mineure ou pas. Voilà. Et peut-être, il existe notamment dans l'exemple du torture free trade, des annexes à ce type de document lorsqu'il y a la norme qui vont venir lister le type d'infraction, comme il existe par exemple des annexes sur le torture free trade qui vont lister les instruments utilisés et qui vont être considérés comme des instruments de torture. Et peut-être qu'il y a des travaux à mener là-dessus, ou s'il y en a, nous serions ravis de pouvoir en disposer. Mais encore une fois, merci à l'honorable commissaire pour cette présentation et pour les travaux qu'il y a.
Thank you so much for the questions raised. I will now invite our speakers to respond and address any of the points they would like to take. Let me start from Honorable Commissioner Manuela. You have the floor, please.
Muito obrigada. Vou tentar, não sei se compreendi direito o que foi perguntado. O que me pergunta o senhor Osman é se há algum mecanismo de acompanhamento depois desse lançamento. Alguma ferramenta elaborada a respeito depois de lançado o quadro? Acredito que seja isto. As instituições nacionais de direitos humanos e as organizações da sociedade civil com o Estatuto do Observador têm toda a possibilidade, e é isto que dizem os respectivos critérios, de abordar a comissão e continuarmos a discutir as questões relacionadas com delitos menores. O quadro de acompanhamento, nas apresentações de relatório que fizerem, porque tanto as instituições nacionais de direitos humanos como as organizações não governamentais têm a responsabilidade de apresentar, de 2 em 2 anos, um relatório sobre o exercício das suas tarefas na respectiva jurisdição. Ora, nestes relatórios poderão perfeitamente relatar sobre o acompanhamento que têm feito em relação à aplicação dos princípios de descriminalização de pequenos delitos a nível da legislação dos respectivos países. E eu digo da legislação por quê? Porque é lá neste primeiro passo que nós devemos acompanhar. Ou quando houver um projeto de alteração do Código Penal, é preciso... Quando houver alteração do Código Penal, é preciso que a Instituição Nacional de Direitos Humanos e todos os parceiros a nível daquele país se envolvam para ver se, existiam crimes que eram de menor gravidade e que devem ser retirados, fazer advocacia em relação à retirada e prestar atenção às novas propostas de crime. Se houver crimes que possam cair naquele grupo que o senhor Lionel pede para fazermos uma lista exaustiva, também devem advogar no sentido de que não sejam inseridos no código. Código, posturas e outros regulamentos internos. Feito isto, se houver alguma questão técnica que precisemos de abordar, podem contactar a comissão para o suporte técnico necessário. Não são precisos mais mecanismos, não são precisas mais ferramentas. A nossa relação, com base nos critérios de outorga, permite-nos perfeitamente trabalhar em comum sobre estas questões. A lista de delitos, caro amigo, sabe que a nossa África é um mosaico, é uma esteira de civilizações. Podemos elencar alguns, mas haverá sempre um ou outro que vai escapar. Por isso é que nós dizemos sempre que esta lista não é exaustiva. Como é que, a nível de área criminal, podemos identificar um comportamento menos perigoso em relação aos demais? É olhando para a pena que lhe é aplicada. Normalmente, quando os Estados colocam menos de 6 meses de prisão, colocam multa, colocam trabalho social, é porque não valia a pena este crime estar no Código Penal. E é esse plaidoyer que devemos fazer. Podemos fazer a lista em conjunto, podemos fazer adendas em conjunto. Isto é um assunto que fica em aberto para podermos continuar a tratar.
Thank you so much, Commissioner Manela. Mr. Kiprono, would you like to add anything on this? I would appreciate if you could be brief.
Yes, I would want to add much more. I think the Honorable Commissioner has really said it all, that petty offences are not exhaustive, but they have qualities in which, when you look at them, you know that this offense is targeted at one marginalized and that is problematic. Thank you.
Thank you so much, Mr. Kiprono, for your reflection. Participants, we would have loved to take all your questions, but due to time constraints, we will be moving to the next session. The next session will be the session 3 will be where we will look at the practical tool developed to track progress on states. But before that, may I kindly request all our speakers to turn on their camera so we can have we can take a few pictures. Thank you. Dylan, please let us know when it's done.
Okay, thank you.
Thank you so much. So we will now move to session 3, where we will look at the practical tool developed to track progress on state compliance. I am pleased to invite Mr. Shan Atad, Executive Director of the African Policing Civilian Oversight Forum, APCOF, to take us through the key indicators and methodology behind the scorecard. Mr. Shan, over to you. We can't hear you, Mr. Shan. You are mute.
I beg your pardon.
Yeah.
I'm just trying to share the screen. And yeah, thank you. So I'm really going to build on from the remarks that Edward made and give a little bit more detail to the scorecard. Essentially, what we're trying to do is provide an easily accessible mechanism to give us an expression of an impression of the extent to which member states are meeting their obligations to the Charter, but to the Charter as interpreted by the principles on decriminalization. The idea is that this is both an accountability tool, but it's also an advocacy tool. So we are able to use it not only to track the extent to which the principles are being implemented, but to understand how that this can be used to further the cause of the principles on the decriminalization of petty offences. And it's done in two ways. One, to give an indication of how we are progressing, but also to provide opportunity to share developments in this field and be able to build off comparative knowledge. So as Edward mentioned earlier, the scorecard really tracks around these four areas of freedom from discrimination, which are part C of the principles, freedom from ill treatment, which are part E of the principles, and freedom from arbitrary arrest, which is part F of the principles, and then the catch-all, the efforts that are being made to be able to achieve this. The results are brought into a diagnostic framework. And here we have been very cautious not to, although it's called a scorecard, not to make this a competitive process, but really to try and understand where we need to place more attention, where we are starting to see results, and where we are progressing. And we've added a fourth area, which we've called a watch point, because in the piloting, it became very apparent that data, and this was mentioned before, data was not always accessible, available. Data was not being recorded. So it was very hard to see how we were progressing. And this watch point then just alerts us to the fact that here we need to make more effort to try and capture, record, and make the data available to assist us in being able to take this process forward. The methodology we'll see includes a basic questionnaire. This has also been refined through the piloting. We've tried to make it as user-friendly and as simple to use so that we can really encourage member states to start providing an understanding of how the principles are being implemented. But we're looking at law and policy, the frame, the foundation on which the decriminalization is built. We're looking at the statistical data, who are being arrested, who are being detained. We're looking at the case law that is starting to challenge some of these areas, the reports that are coming from human rights bodies, NHRIs, and others that are starting to alert us to ill treatment, discrimination, and arbitrary arrest. We're looking at the secondary sources of information available from academia, civil society, and the media, and then case studies as they are emerging. And that this data then allows us to build up a picture of the extent to which the principles on the decriminalization of petty offences are understood and are being applied in that jurisdiction. The information is then presented really against two matrices. The one is the threats that are being tracked, so the extent to which there's an impact on marginalized or vulnerable groups, the extent to which there's criminalization of life-sustaining activity, the effect of policing processes and the enforcement of policing practices, the potentials of discrimination and arbitrary practice, the extent to which there's imprisonment for non-payment of fines, or the alternatives available to imprisonment and overcrowding. And then we're looking at the reform measures that are available to us. So the extent to which we're seeking to actively implement the principles on decriminalization of petty offences, the revisions that are starting to take place around sanctions for these petty offences, and the extent to which we're starting to see public education and awareness coming through. And this is condensed then into a fact sheet, which is available both on the website, but also in a way that is printed. It can be printed out and used for ongoing advocacy purposes. And it sets out across a number of chapters. The criminalization of life-sustaining activities, sanctions for petty offences, policing enforcement practices, the disproportionate impact that this is having on vulnerable groups, imprisonment for non-payment of fines, reform measures, and public education and awareness. The fact sheet is presented in a very short and sharp way, so it's easy to read, easy to distribute, easy to use to engage public officials and others around the importance of ongoing efforts to decriminalize petty offences. But importantly, both in the website and on the fact sheets, the information that is informing this summary of where we stand is available through hyperlinks. So what we've tried to do is, as this rich information has been collected on statistics around arrest, efforts around law reform, changes in sanctioning practices, commentary on policing approaches, as this information is collected, we've made it directly available. So if anybody wants to do further research or to use that to dive into any of these areas, that is available. And this stresses the comparative component of the website, not in terms of who's doing better, but that we can learn from each other around these various practices. So we have, as we've said, the three pilots that have been done. We've assessed them against the information. We've indicated the extent to which there's progress, there's concern, or there's a watch point. These got to voir. We really need more information, and we've indicated that as an area where we can build up our understanding of the extent to which decriminalization objectives are being met. We've indicated ongoing high concerns in Kenya and moderate concerns in South Africa. Certainly, there is a lot of work to be done, but we're starting to see some reform and some understanding around the importance of addressing the decriminalization of petty offences. The final point I want to make is that this is certainly, we see this as a very dynamic interface. So these results are not results that would then determine how decriminalization is viewed in that particular jurisdiction. At any point, more information can be brought in. Those situations can be changed. Additional fact sheets can be developed and put on, and we can really see it grow, not only in terms of the countries contributing, and it's very encouraging to hear the remarks from Cameroon around how this could be a very useful tool for the Cameroon, but in country as well, we can start seeing a difference added, and the principles on decriminalization kept vibrant and alive. So at that point, I thank you very much, and we will now have a look at the site itself. Thank you.
Thank you.
Thanks, Mary.
Thank you so much. Thank you so much, Mr. Shen, for taking us through the methodology. It's clear that a lot of work has gone into developing this tool. I believe this has really helped to make the platform comprehensive, Thanks once again, Mr. Shen. Colleagues, now we have reached the exciting part where we get to see the scorecard in action. I am now pleased to invite Mr. Jofal, co-founder of InDesign, who will take us through a live demonstration of the online platform and show us what the scorecard looks like. Jojo, the floor is yours.
Thank you, Maron, and good afternoon, everyone, once again. My role today is more on the communication of this platform and how we have thought through the visualization of the information. The web tool sits on the Campaign to Decriminalize Poverty and Statuses website, which is also has a lot of resources around petty offences and the progresses that have been made in terms of decriminalization. So when you get to the home page, if you scroll a little bit down, you get to this section, which talks about the petty offences scorecard and takes you directly to the landing page of the scorecard. On this page, you'll have a very brief overview of what the scorecard is about, and then the 3 pilot countries and what not ranking, but rating and grouping they've been put in, as well as a read more button to those country pages. Scrolling further down, you get more information as to what's behind the scorecards, why this matters, what it measures, and how the scoring system works, as well as where we are currently at in terms of populating the scorecard. So as you know, we've piloted in 3 countries, so South Africa, Kenya, and Cote d'Ivoire, and I'll go through those country pages as well. But before I do that, I just want to point out at the bottom, this is really where we want people to start interacting and contributing further information to help populate and grow the scorecard. I'll go into a bit more detail on that, but let me show you a country page first. We can take Cote d'Ivoire as an example. So once you click on that country page, you get a quick snapshot overview of where that country is, and then a breakdown based on the different areas and metrics that were looked at. So the criminalization of life-sustaining activities, including the links to the information that Sean mentioned, so you can really deep dive into the background evidence behind this information. The sanctions for petty offences, what are the case laws, and what legal data exists that people can take a look at. Police enforcement practices have also been summarized and outlined with links again to further information. The disproportionate impact on vulnerable groups is also listed, imprisonment for non-payment of fines, and the relevant case law for that particular country. And then scrolling further down, reform measures, public education and awareness, and then further reading and resources as well. So you can see it's very succinct and concise so that it doesn't overwhelm the reader. But for those who need further information, they can very quickly click on the links and get more data and information regarding that country. I'm also going to show the snapshot that Sean mentioned in a bit more detail. So this is it's a 4-pager that can be printed, presented in workshops, or if you're having conversations in meetings with policymakers, and it basically holds the same information as what's on the website, but just in a printable form that makes it easy to distribute or forward on email, etc. And the idea is that each country would have a snapshot like this, which summarizes their country pages. And for more information, the website is also there that talks more to the depth of the work. So going back to the scorecard, again, you'll have the same similar setup and information for all the different countries that we currently have. But I wanted to show primarily the form through which you can make contributions to the information that are country specific, etc. It's quite an open form. You can add in as much information as as possible or as little as you have, just by specifying the country and the name of organization and your contact details. I'm going to just do this very quickly so that you can see an example of one of the questions. And this gives an opportunity, for example, for you to submit information about your country. So it's simple questions like, are there laws that criminalize life-sustaining activities? Yes, no. Do you have some of that information? Can you send in a hyperlink? If not, how is this dealt with in the States? And it goes through all of the different brackets and sections of the form. Excuse me, sorry. And that gives a quick overview of the two sections, the web tool itself, but also the questionnaire that allows you to contribute. And so that brings me to the end of the presentation. And let me opens the floor for any questions as to the form and the data that is being presented. Thank you. Meron, you're muted.
Thank you so much, Jojo, for that practical demonstration. We have now a clearer picture of how the scorecard works and how it can be used to support monitoring and implementation. We will now open the floor for a short Q&A session. Since we are running out of time, I will take only 2 questions. Kindly raise your hand, then I will allow you to speak. Any question? Okay, I don't see any hands. Okay. Janile, you may ask the question. Kindly introduce yourself, just your name and then the organization you are representing. Thank you. Please proceed.
Thank you very much, Maren. This is Janelle Mangwanda from the Dalla Umar Institute at the University of the Western Cape. Thank you to all the speakers for your contributions. I think the scorecard is a very exciting tool, and I'm looking forward to reading more about it. Jojo has presented to us how we can complete the form. My question is, in order to form a substantive amount of information about a particular country, is there a threshold of how many entries for a particular country is needed for an actual scorecard for that particular country to be presented? Because, for example, if one organization in South Africa, for example, fills in the form, or 3 or 4 organizations, is that sufficient, or is there a particular threshold at which we then say that, okay, after 20 organizations fill the form, then we're able to generate the scorecard of whether it's a green or a yellow or a red, like it was shown? Thank you.
Is there any other question?
Meron?
Yes, Honorable Commissioner, you may proceed, please.
Ok, obrigada, Meron. É uma ferramenta extraordinária e, como eu disse na minha apresentação, o grande problema que temos tido durante as campanhas sobre descriminalização de pequenos delitos é a expansão dos instrumentos em todas as línguas. A minha pergunta é, esta ferramenta pode ser utilizada também em outras línguas que não seja inglês? Obrigada.
Thank you so much, Honorable Commissioner, for the question. And Daniel, I now give the floor back to Jojo to respond to the question. Jojo, you have the floor.
So sorry, I'm trying to turn over to. So in response to whether the tool will be translated, there are plans to translate it in the future, depending on the resources. For the pilots, those should be able to be translated in the next coming weeks, but we wanted to get this out the door first. And in terms of the information being gathered per country, there's a review process that needs to happen, which will be between NANRI and APCOF, and I'm sure they'll respond to that, but it really does depend on the resources that we have available. But it will always sit on the campaign site as a reference tool to for those who want to use it for the future. I hope that answers the two questions.
Thank you so much, Jojo, for responding to the questions. Mr. Shan, is there anything that you'd like to add?
No, simply just to reiterate what Jojo said, is that the filling in the forms will give information, but not post that information onto the website. This will be done through an analytical process led by NANRI and ourselves and others, if anyone else is involved, who will then use this data to be able to produce a response or a picture of that country's progress towards decriminalization. There certainly isn't a limit to how many of the forms can be filled. There isn't a limit to how much information we're going to be getting. But what we are interested in doing is seeing that progress being made, even with little information, and being able to then perhaps present that as a watch point, but certainly encourage that we keep on contributing to it and build up the database of progress around decriminalization of petty offences. Thanks.
Thank you so much, Mr. Shan and Ms. Jojo, for the excellent presentations and for the work that has gone into making the scorecard a practical tool, and also this launch possible. I would like also to thank all our participants for the engaging questions and our panelists for their valuable responses. We have now reached the final part of our program. I would like to invite Mr. Gilbert to officially launch the online scorecard platform, which will be followed by his closing remarks and vote of thanks. Mr. Gilbert, the floor is yours. Thank you.
Thank you. Thank you, Meron. Thank you, Jojo, for the good presentation. And thank you, Sean, for having contributed to the development of this scorecard. At this stage, I think that we can only announce the official launch of our scorecard. I think the scorecard is officially launched. And on behalf of NANRI, I would like to thank you very much for this, hoping that we will use this to really allow the implementation of the African Commission principles. On this note, now, as we come to the close of this important occasion, we do so having reached a significant milestone in our collective efforts to advance human rights, dignity, and justice across the continent. Today, on the International Day of Criminal Justice, we have taken an important step towards strengthening accountability and supporting criminal justice systems to uphold the rights and dignity of all. It is therefore my great honor and privilege on behalf of NANDRI and our valued partners to officially launch the online scorecard platform on state compliance with the African Commission principles on the accumulation of petty offenses in Africa. This platform provides a valuable tool to support monitoring and advocacy efforts towards advancing reforms across the continent. This is an important moment, but it's also the beginning of the real work ahead. The pilot assessments undertaken in Kenya, South Africa, and Cote d'Ivoire have provided us with a valuable baseline and demonstrated the relevance and potential of this tool. However, our ambition must extend far beyond these 3 countries. And I thank you for having raised the issue on how to utilize it and how to fill the form. As we conclude today's event, allow me to leave us with 3 important calls to action. First, to NHRIs, I encourage all NHRIs across the continent to actively utilize this platform. While Kenya, South Africa, and Cote d'Ivoire have provided the foundation through the pilot phase, we call all NHRIs to use the scorecard, contribute relevant information, and help strengthen the evidence base on compliance with the African Commission principles. To our friends from civil society organizations and research institutions, I call upon all of you to actively engage with this platform, use the evidence generated to strengthen advocacy, and contribute relevant information that will help advance monitoring and reform efforts. To our partners and supporters, I encourage you to sustain this momentum by continuing to support and invest in the expansion of this important initiative. Your partnership will be essential in ensuring that more countries across Africa benefit from the methodology and advance criminal justice reform. Distinguished members, dear participants, finally, I wish to emphasize that an initiative of this importance and scale cannot be achieved by one institution alone. It is made possible through strong partnership and a common vision for a more just and inclusive Africa. Allow me, therefore, to express my sincere appreciation to all those who have contributed to making today's launch a reality. First, I would like to extend our deepest gratitude to the African Commission on Human and People's Rights, presented here by Maria Teresa Emanuela, for its continued leadership to advancing regional human rights standards. These standards provide stakeholders across the continent and beyond with an important foundation for advocacy, engagement, and the promotion of human rights. To our core partners, the African Policing Civilian Oversight Forum, under the leadership of Sean Tait, and the Global Campaign to Decriminalize Poverty and Status, thank you for your invaluable technical expertise, collaboration, and dedication in co-developing this scorecard. To our generous funders, including the Open Society Foundation, we extend our profound appreciation. Your financial and strategic support has transformed this vision into a practical tool that can contribute to meaningful reforms across the continent. To the pilot team, including NHRIs and civil society actors in Kenya, South Africa, and Cote d'Ivoire. Thank you for your dedication and willingness to test and strengthen this initiative. Your contribution have provided the first important body of data that will guide future efforts. Finally, to our speakers and all participants joining us today, thank you for your time, your thoughtful engagement, and your continued commitment to advancing justice and human rights across Africa. As we conclude, I firmly believe that this scorecard would serve as a valuable instrument for strengthening accountability, informing advocacy, and supporting reforms towards the decriminalization of petty offenses across our dear continent. It is through value will be realized through its continued use, engagement, and contribution by stakeholders across the continent. Once again, I extend my sincere appreciation to all our partners, colleagues, and participants for your commitment and support. I thank you all and wish you a pleasant weekend ahead.
Thank you very much, Mr. Gilbert, for officially launching the scorecard and for your closing remarks. With that, we have come to the end of today's webinar. On behalf of NANRI and our partners, I would like to sincerely thank Honorable Commissioner Manuela for joining us and sharing her valuable insights, as well as all our speakers and participants for your time and contributions to this important discussion. We look forward to continuing this important work together. Thank you once again, and we wish you a wonderful day.
Thank you.